provide the revenue for. The protest, the proponents and the Attorney General, which has filed briefs in this case, essentially take the position that there cannot be a referendum because this is a revenue bill. And we would submit to the court that that is incorrect for several reasons. Number one, Article 5, Section 2 is still intact. The exception outlined in Article 5, Section 2 was not at all changed by State Question 640 26 years ago. And there's several key components to that. Just last year, 2017, this court said in Oklahoma Automobile Dealers Association versus State of Oklahoma that the purpose of State Question 640 in paragraph 7 first had the effect of limiting the generation of state revenue to existing revenue measures, and second, it required future bills intended to raise revenue to be approved by either a vote of the people or a 3/4 majority in both houses of the legislature. When you look at Section 33, which is what State Question 640 addressed, in Section C, it says that revenue-raising bills in Oklahoma have to go to a vote of the people. That's what it says. That's the first purpose, except there's an exception. It says, and not otherwise except as provided in subsection D, which then says any revenue bill may become law without being submitted to a vote of the people if we get this supermajority of 3/4. 26 years, one time, which is why we're here today. The proponents and the Attorney General would take these two provisions and say State Question 640 did something beyond that, that it either has to go to the vote of the people, but even if it goes to a majority vote and passes the 3/4 supermajority in the legislature, it's still a vote of the people. Because any revenue bill has to go back to the vote of the people via referendum.
Counsel, I don't understand their argument to be that it has to, just that preserves the people's ability to have a referendum on a revenue bill that's enacted by the legislature.
I think if you read their brief, one comment was made that if it's a revenue bill, then it has to be subject to referendum. And I think our position is that's not true because they didn't amend in State Question 640 Article 5, Section 2. They very well could have. They could have amended Article 5, Section 2 and state, for example, a revenue petition can be filed except for laws that are immediately necessary for the preservation of peace, safety, or health. I'm going to mess that up several times. Or it can't be used for a revenue-raising bill. Didn't say that. And we have precedent in Oklahoma to why the exceptions to referendum petitions should be followed by this court. And I think the first one is looking at House Bill 1023. You can't look at House Bill 1010 in a vacuum, as the Attorney General and the proponents would suggest that this was just some isolated revenue-raising provision. It was specifically tied in and contingent. Several other bills were passed along with it. The raise for support staff, the raise for state employees, the school operations bill, which included textbooks and monies to refund past shortfalls in the education budget. But specifically the teacher pay raise bill, 1023, says it is contingent upon the enactment of 1010 and has a specific emergency clause in 1023 and says that it shall not become operative otherwise.
What's your position? Has 1010 been enacted?
It's a good question, Your Honor. We believe, I think they're quabbling about that. Here's my response to that. I believe the state of Oklahoma is in a catch-22, in my opinion. Because if they argue, and this question has been proposed by the State Department of Education to the Attorney General's office, because school districts across Oklahoma right now are telling their teachers these raises don't go into effect. They're awaiting the outcome of this court and this protest. Just last week, we got an email to our office from Union in Tulsa, specifically telling them. And
wait, how do you define enactment?
I defined enactment basically when it becomes enacted, but in this case, it says it shall not become law operative otherwise. And I think that, but my point is, I think that I'm not the one who's going to make that decision. The state of Oklahoma, in fact, the Attorney General has been asked this question. And if they say that 1023 has not been enacted, now we have the situation in Article 5, Section 2. Because now you have this referendum directly affecting a law that the legislature has said is immediately necessary for the preservation of peace, safety, and health.
Without this referendum petition, then you wouldn't be quabbling about enactment. 1010 would have been enacted and 1023 would have been enacted. So until this referendum petition was filed on May 1st, these bills both passed in March of 2018. So are you saying they were not enacted when they were signed by the governor?
No, Your Honor. I'm saying they are enacted. What I'm saying is they're taking the position that the contingency language, these bills have contingent language and shall not be operative otherwise, is what it says. I don't know the answer, but what they are saying and suggesting to this court is that 1010 essentially has no effect on these other bills. And if that's the case, then the Oklahoma legislature just passed bills with a $500 million funding for public schools, and the revenue bill to support it is on hold. This court said in 1991 that public school deficit financing could be a situation that a referendum petition should be declared unconstitutional, legally insufficient. That's the catch-22. If they say the teacher pay rate bill is in effect, then all these public schools have these obligations legally to pay these teacher pay raises and other raises, and they don't have the funding mechanism.
Well, I'm sorry.
No, go ahead.
What's confusing me is it seems like you're using effective and enacted interchangeably, and I understood those to mean two different things, that these bills have all been enacted, but they haven't become effective yet, because you enact the bill and then there's an effective date that occurs 90 days or however many days later. So they've been enacted. The question is whether they will ever become effective. And that's what the referendum is determining, whether 1010 will become effective. Is that a fair way to look at it?
I would say that's fair. I would say the other issue there is the language in 1023 that says it shall not become law, shall not, I have it written here.
Operative.
Operative as law otherwise. That's language that I don't know what that means. But
what about the emergency clause in 1023, the emergency clause? What effect does that have?
Well, I think that's exactly our point, which is that you can't view 1010 in a vacuum. 1010 has these bills that are contingent upon 1010 going forward, including 1023. That's the problem, is that if you allow this referendum to take place, you are in effect having all of these laws that the legislature has declared via emergency clause need to be implemented right now. That's the problem. The second one is regardless of the contingency in these other bills. In 1991, this court was faced with House Bill 1017 and In Re Petition 347, 1991 OK 55. This Supreme Court dealt with an initiative petition that basically sought to restore education reform and financing prior to House Bill 1017. One of the arguments in that case was, well, this is actually a referendum. And neither the Attorney General or the proponents of RP 25 can deal with this court's statements about the support of public schools and the exception that this court has recognized that should not be allowed to be subject to referendum petition.
Can you clarify something there? Do you view that as a second exception, or are you saying that all things relating to public education are inherently necessary for the immediate preservation of health, safety, welfare?
Good question. I think the exception is broad, and I think we said that in our reply brief, where they argued that other states have other provisions in there. This is a broad exception, and this court has the ability to interpret laws. It has the ability to declare which laws it feels like fall under the exception of Article 5, Section 2, and it's done so. Back in 1950, when it talked about referendum petitions, Sure, we agree. We said it was, it cited to a Missouri case and went off that Missouri case. Nothing's wrong with Missouri, right? Maybe if it was a Texas case, we'd have a problem.
Doesn't
but
Missouri have a different constitutional provision?
They do, yes. And in that case, in 1950, they quoted the Missouri language, and then they gave an explanatory paragraph about that language. And had we only had the 1950 case, that might be an issue, but we don't. In 1991, the court was dealt with House Bill 1017 and specifically said and outlined. At that case was an initiative petition. The Attorney General argued, well, they were really speaking to the fact that 1017 had an emergency clause in it. That's not what the opinion says. The opinion says nothing about 1017 having an emergency clause. The issue was that 1017's subject was education financing and reform and taxation. That's what the issue was. And specifically, this court said, there can be no dispute that as a referendum petition, this state question would be invalid, as fully illustrated in the 1950 case in re referendum petition number 1. Then quoted the paragraph from the Oklahoma Supreme Court from 1950, then said this subject would not be appropriately addressed by a referendum petition. There's no talk of that there was an emergency clause in 1017. The issue was pertaining to the support of public schools, that this court has recognized that when you have laws pertaining to the support of public schools, that falls under the exception of Article 5, Section 2.
Wait, I hate to press you on this, but I do need, because it matters to me how I look at this. Do you view that as a separate exception or subsumed within the exception that's actually in the text of the Constitution?
I believe that's subsumed within the exception in the Constitution.
So anything that relates to public education is always immediately necessary?
I think it's pertaining to the support of public schools, which is what it said. And the cases that we have, at least in 91, talked about financing and taxation pertaining to the support of public schools.
What if it was a bill that wasn't going to go into effect for 2 years, but it relates to that subject? It's nonetheless emergency, immediately necessary. It seems to me there has to be a line somewhere. It's either immediately necessary or not.
I agree. And I think public schools, with respect to the support of public schools, at least we know from House Bill 1017, this court would have said, I don't know about other issues, but I know on school finance, which is what 1017 was, we know that in fact the court relied on that language and said had it been a referendum, it would have fallen under the exception of Section 2. That we know.
That language was dictum in that case though, right?
I don't think it was dictum. The reason is because one of the issues raised in that case was the people fighting against the referendum were saying this is actually a referendum clothed in the guise of an initiative. Because here's the deal. There is no exception to the initiative petition. There's an exception to the referendum petition under Article 5, Section 2. What they were arguing at that point was, hey, what they're really trying to do is repeal 1017, thus it's a referendum, thus based on this law, this should be rejected. And the Supreme Court in that case analyzed it and said, no, we believe it's actually an initiative. But had it been a referendum, it would have been no dispute, it would be invalid and can't move forward under the exception to Article 5, Section 2. And the only argument against that case is essentially, well, that quoted a Missouri case from 1950. Well, it did in 1950.
Counsel, in the Missouri case, the Missouri Constitution had the specific language about public schools.
Agreed.
Does the Oklahoma Constitution have that?
No.
So how can you compare apples to apples here?
I think because of what the court has done. The court can say what laws and interpret which laws fall under the exception to Article 5, Section 2. We believe it's a broader exception. Any law that affects the preservation of health, safety, or peace is not subject to referendum.
Well, the argument's not with health, safety, or peace, but it's with public education. The public education language to support public schools, public education is unique to the Missouri Constitution. It's not in the Oklahoma Constitution.
I agree.
Your argument is the Supreme Court at that time made that connection, that elaboration, but it's not in the Oklahoma Constitution. I think that's the position that the proponents take.
And I understand the position, Your Honor, but I would suggest that this court has the ability to say which laws it deems fall under that exception. And we know that for whatever reason in 1950, the Oklahoma Supreme Court thought that language from Missouri was significant, thought the pertaining to the support of public schools was significant. And we know in 1991, they thought it was significant because they put 3 to 4 paragraphs in here about it and specifically said, if House Bill 1017 in 1991 had involved a referendum petition, this court stated unequivocally it would have been invalid.
But it was undisputedly a bill necessary for the immediate preservation of health, safety, and welfare because it had an emergency clause, which means there's a legislative finding that it's necessary for the immediate health. So couldn't we have just as easily been talking about that?
We could have if they would have talked about that. And that's what I stated earlier.
Yeah, but that's a negative. And it also didn't say anything specifically about the subject being public education, but you want us to read it that way. So why is one reading better than the other when it's silence?
I think because if you look at paragraph 4, which is the paragraph that the Attorney General cited to, it outlined all of the basis for the objections to the petition in that case. Outlined every one of them. Said the gist of the proposal is deceptive. Section 5 prefers one religion over another and is therefore unconstitutional. There's due process arguments. And the text of the measure violates certain provisions. Never did it even mention the fact that the bill had an emergency clause, and immediately went to this whole provision and cited to the 1950 case. The 1991 court quoted the paragraph from the Supreme Court in 1950, and that's why I would suggest it's not a negative in my opinion because they were quoting from it. And in my opinion, we're re-emphasizing and reaffirming the fact that for whatever reason, this court, well, I think there's a lot of reasons. If you live in Oklahoma and you're involved in what was happening in March and April, you know that the support of public schools in this state is a major deal. We were in a crisis and are in a crisis. This is the first time in 26 years we had a bill passed to fund education in this manner. So I don't think it's a negative. I think they were specifically citing to it. They quoted the paragraph and then went to lengths to suggest that had House Bill 1017 been a referendum, it's invalid. What's the difference here is our position. There is none. It's the same type of provision. It's the same type of bill. And like the Supreme Court has said and adopted, that the support of public school is important enough to the people of Oklahoma that a referendum petition cannot pass, and I'll reserve the rest of
And
my
you don't think 640 changed that? You don't think that that's what they mean by the change in 640, that you can no longer have an emergency?
Absolutely not. And I can reserve my time for rebuttal if you want me to address that. Or...
That'll be fine.
Okay,
You've got 10
you.
minutes left.
Thank you.
Mr. Bowers.
Good afternoon. May it please the court, counsel for the protestants. My name is Barrett Bowers, and I represent the proponents of referendum petition number 25, Dr. Tom Coburn, as well as Rhonda Vullamont Smith and Brooke McGowan, who are here with me today. Referendum petition number 25, in my mind, justices, is very, very simple. It asks to submit to a vote of the people House Bill 1010XX. That's all it does.
It says to repeal it.
Yes,
Yeah.
exactly,
So
to repeal.
how does that submit it to a vote of the people?
Yes, to submit it to the people to determine whether or not
It
House
should be
Bill
repealed.
1010XX.
And what does a yes vote do?
And what a yes vote does under the ballot title that we have currently, repeal of 1010XX. And of course, those issues are raised in depth by the other protest that was filed that we'll address later on. But I think that referendum petition number 25 is very simple. It asks the people to repeal 1010XX, a significant tax increase that's been imposed by the Oklahoma legislature. And what we've heard so far today by the protestants is simply policy arguments that House Bill 1010XX should be law, that it is a good law, that there's a crisis if we don't have 1010XX. But those are all policy arguments that are not appropriate for this court's gatekeeping role when considering a referendum petition. And so
The language now, I think, is whether or not the question that's submitted on referendum shall be approved. So a yes vote should be for the approval of the legislation, shouldn't it?
Well-
That replace the old language, should it be vetoed?
Well, that's absolutely correct. In 34 OS Section 1, that's what the language identifies. It says that shall the bill be approved. But this court has addressed this particular issue in reverse in the past. In the prior decision of this court, it said we had a petition, and I'll get the case site for you, Justice, and this was in the matter of referendum petition number 130, 1960 OK 185. That was a case where the petition still said it must be vetoed. Shall the bill be vetoed? That was the language at the time in 34 OS Section 1.
But laws 1961 say the question we herewith submit to our fellow voters is, shall the following bill be approved? And you're telling us a yes vote would be the equivalent of a repeal.
What I'm telling you is that in 1960, this court dealt with an issue addressing the statutory language that said the opposite. Shall the bill be vetoed?
Well, I want to know what's going to happen to our voters this summer. How clear is the situation going to be to them, or how muddy, as you've just made it to me?
I think it's going to be perfectly clear, Your Honor.
Well, I'm glad to hear that.
I think that the issue is more appropriately addressed later with the protestants who have raised those issues and the challenges to the gist. This challenge addresses a different issue. And this challenge specifically, I think that as you've just heard, says, number one, that referendum petition number 25 is legally insufficient and invalid because the repeal of House Bill 1010 will lead to the repeal of House Bill 1023. And
Can I ask you the same question I asked them? Has 1010 been enacted?
I think it absolutely has been enacted.
So what is your position if you get your signatures and the people reject 1010 subsequently such that it doesn't become effective? Are 1023 and 1024 enacted and effective law?
Absolutely. Okay. Absolutely. Under my reading of 1023, that bill is operative once 1010 becomes enacted. And under what we've briefed in the case law, specifically Norris v. Cross, once the legislature passes the bill and it's signed by the governor, then it has been enacted. It may be operative at a later date, but it is enacted.
How do you justify the contingency language?
I think that you have to read the specific language and see what it says the contingency is. The contingency is if 1010 is enacted, then this law will become effective. It has been enacted, and so therefore that contingency has been met.
What do you think they intended?
I think that I don't know that it matters what they intended because, number one, ultimately that question to me is not an appropriate question for this court to answer, because what that is a backdoor attempt by the legislature to try and prevent or prohibit a referendum on a piece of legislation that does not and absolutely cannot, pursuant to the terms of Article 5, Section 33, include an emergency clause. So I don't know that it makes any difference what they did or didn't intend, but I think that we have to start in answering that question, Justice, is what is the language that they used and how has that language been interpreted by this court in the past? And the specific language that's used is the word enacted. And so I think that they intended exactly the result that we have here today, and that's why certain people in the legislature voted for one bill but not the other, and the vote counts don't match. And so what you have...
So what's the impact then of the referendum if it passes, it unenacts 1010?
No, I don't believe that it unenacts 1010. I think that it has been enacted and it will never become effective or operative.
Okay, so tell me the difference between effective and inactive. Enacted.
I think under the Norris v. Cross case from 1909, I believe, an enactment is when all the formalities of the legislation have been completed. An enactment then becomes effective either immediately upon enactment or at a later time, depending on what the Constitution or statute or rules that are in place say. In our Constitution in Oklahoma, Article 5, Section 58 makes it clear that an act that has been enacted is operative or effective once it ultimately passes that 90-day mark, unless it has an emergency measure in it.
I'm confused. Signing die has to occur the end of May at the latest. In this case, it occurred first part of May. 90 days begins to run at that point. Fiscal year begins July 1. So even at the end of May to July 1, you're talking 30, 35 days. But yet the effective date can be as late as another 60 days.
Mm-hmm.
How does that work?
That's what works pursuant to the Constitution.
But what does it do to impact the contracts that the school boards across the state are signing with their teachers?
Well, once again, the teacher pay raise has an emergency clause in it. It is immediately effective. We do not believe that 1010 is necessary for 1023 to go into effect. The repeal of 1010 will not result in the loss of the teacher pay raises. That is
be funded, Mr. Bowers.
I think it would be funded, as we can see currently, that we're going to have a significant surplus in the state, and that our receipts for the past month, May and June, are expected to be some of the highest ever. And so,
Is that speculative?
no, that was certified by the state treasurer for May and June of 2018. These receipts of tax revenue is significant right now.
Your position is the teachers get the money regardless.
Our position is the teacher gets the money regardless. That is what our position is. 1010XX is just a source of funds. There are other sources of funds that can be used to fund that teacher pay raise, and I think that's clear when you see that 1010XX does not send all that money to the teachers. That's not what the purpose of that bill is. That money goes to a multitude of different places.
Some of which are education.
A couple, yes, some of it, yes. But and to tap into that, I think that what you see, and when you talk about the pertaining to the support of public schools, that was an argument that was raised by council and by the protestants here, is can a piece of legislation that pertains to the support of public schools, can such a piece of legislation be submitted to the people for a vote through the referendum process? And I think the answer to that question is absolutely yes, because State Question 640 mandates that any revenue bill may be submitted, even after approved by a supermajority, to the people for a referendum. And like you pointed out, our Constitution does not have this provision that the Oklahoma Constitution has, or excuse me, that the Missouri Constitution has, that prohibits a referendum for any bill that touches on or pertains to the support of public schools. I don't think that argument carries much weight with it, and I think that it's incorrect as just a matter of law. And you can see that there's just simply no support for that in the language of the Oklahoma Constitution. And beyond that, too, on that issue, I believe it's wrong to suggest that this court has a roving authority to determine under Article 5, Section 2, what bills constitute an immediate, or what bills are immediately necessary for the preservation of the public health and welfare. That's a legislative determination. That is not a determination that can be or should be made by this court when interpreting Article 5.
Would you address the repeal by the governor, of the legislature and signed by the governor of the motel hotel tax, and how that impacts the initiative referendum?
I think that the repeal of the hotel motel tax really, it just tells us that that tax is not at issue. I don't think it affects our referendum petition number 25 at all. We don't talk about the hotel motel tax. It is not at issue. It's gone. It's been repealed. There is no authority, in my opinion, that says that the legislature can't repeal an act before the referendum petition has started.
Mr. Bowers, your referendum is on 1010.
Yes.
Double X.
Yes.
1010 double X, at the time that it was enacted, signed by the governor, included the hotel motel tax.
Yes.
Did it not?
It did.
So how can you just not, on the one hand, you're saying what happens afterwards is important, so we don't have to talk about it. And on the other hand, you're saying on 1023, what happens afterwards Doesn't matter. Which one is it? Either it does matter or it doesn't matter. It doesn't matter with regard to hotel mo tax, but it does matter with regard to 1023, the teacher pay raise. Which one is it?
Well, I don't look at it, I don't look at myself as trying to have it both ways, Your Honor. I don't think that's the analysis that I'm going through. Whether or not something matters after the fact depends on what language is used. In this case, the legislature in 1023 said it is that 1023 is contingent upon the enactment of 1010. 1010 was enacted at a precise point in time, and it can't be unenacted. It just will never become operative or effective. And so I don't think I'm trying to have it both ways. I think the hotel motel tax is just a totally different issue. And so what happens after 1010 is signed, the very next day when the hotel motel tax is repealed, ultimately you see that it's gone. It's gone, and there's no need to address it because it's not going to affect the voters.
But it's still in 1010XX as filed with the Secretary of State as an enacted law. And yet you choose to delete it, not talk about it, not mention it. To me, that's inconsistent.
Well, I think that what's important is when you look at the gist. And again, I feel as if I'm addressing arguments that we'll hear really in depth at the next protest here, and not addressing some of the arguments that were raised by these protestants. But just briefly, I see those issues as very different. The hotel motel tax has been repealed. There is no need to address it in the gist of the proposition.
But that's not the issue. The issue is when you circulate your petition, and I assume you're circulating it now for signatures, is that correct?
That is correct.
So if someone who's a voter says, I want to look at the text of the bill, and they look at the text of the bill, and the text of the bill has in it a hotel motel tax, because that's what you do when you circulate the referendum, similar to when you circulate an initiative. And in other cases, it seems to me that some of the issues have been resolved because people actually get to see the text of the actual legislation. But isn't that misleading in this case because there's no reference to what happened to the motel hotel tax?
No, I don't think it's misleading at all. I think that the omission of that detail, even if the hotel motel tax was still in effect, I think the omission of that detail would not be misleading. It's still a very minor part of that tax increase, and this court has held on several occasions that even the omission of substantive details is not fatal to the gist of a proposition if it doesn't include those details.
Yeah, but this is a little bit different because this includes it, and it's been repealed under your theory that because 1012, I believe it was enacted in April, it repealed it. So enactment, and nothing in 1010 will affect 1012. And I just for sake of argument, but in this case, it's still contained in the text of the entire statute. So what would happen if someone says, I don't understand this?
I don't know what would happen. I think what would happen is that with the gist of a proposition, you're talking to voters and signatories who want to repeal 1010XX. You're not talking to people who want to approve 1010. And so when you're talking to...
How do you know that when you go out and circulate a petition?
Well, that's the point of getting the signatures. The people that sign that pamphlet and sign those signature sheets are not people who support 1010, because there would be simply no reason for them to put it on the ballot. You don't know when you go up to an individual, do they support or do they not, but the people who sign that pamphlet and those signature sheets, those are people who oppose the tax increase. And so that's who ultimately your audience is when you're circulating these pamphlets.
Aren't they more inclined to oppose the enactment of 1010XX if the odious lodging tax is attached to it?
I just think that's speculation about particular voters. It's a minor part of the significant tax increase.
You think it's minor?
I think that when you talk about in terms of percentages, it's less than 10% of the entire tax increase, the hotel motel tax. And so when you talk about we're addressing 90% of the bill, the other 10% is just another tax. This is not.
How many teacher pay raises would that be?
I don't know, but I don't believe that would impact the teacher pay raises. I think that it won't impact the teacher pay raises And once again, I think that's more of a policy issue, is what should we do or shouldn't we do? That's up to the voters at the polls.
If your position is that you can't reanimate that tax by referendum, I mean, the Constitution says you can do a referendum as to only parts of a piece of legislation. Why didn't you exclude that tax from your referendum?
Well, I think that there's really not a good way to do it whenever you get into a situation where the legislature has repealed a part of a law. And I think that there's...
Well, the hotel motel tax is sections, although it's not numbered and you can't find it unless you go through the whole thing. It's sections 9, 10, 11, 12, 13, 14, 15. The only thing left is section 16 with just 2 lines. Mm-hmm. But it would have been real easy to do your referendum on only sections 1 through 8 and 16 and not affect the hotel motel tax. You chose not to do that.
But the problem is that this court's role is not to say, could we have written a better gist or should we have done it?
Our role is to protect the voters.
Certainly.
Can you tell me why you didn't put an exact copy with the paragraph numbers?
I cannot tell you the answer to that question.
Could you tell me what you asked the people when you asked them to sign? What do you tell them?
I am not personally asking any person to sign anything.
No standard sort of, do you want to sign this to repeal the taxes, or?
I can't answer that question, Justice.
Because when I walk into people, places where they say, you want to sign this petition, and it's certainly not very much explanation. Mm-hmm. Of course, I can't sign any of them.
No, we just say no.
Right. I think to address all of these concerns, we can look at the State Question 639 case from 1991. That case addressed a very similar issue where the legislature had repealed a portion of 1017 prior to the time that the initiative petition was circulated. And this issue was addressed by this court, this precise issue. What will happen because the legislature took a step to repeal a portion of 1017? And this court said, we're going to exercise judicial restraint and we're not going to get involved in speculation about what might be the case here, because the ballot title and the gist puts everybody on notice that what is at issue is in that case 1017. In this case, the issue is 1010. And so we have a very close analog to this issue, and the court did not find it misleading in 1991, and I don't believe it's any different today.
Well, it's not necessarily a question about the gist, and I agree that you can't enact new positive law by referendum. You can only do that by initiative. So I don't think the referendum can reanimate the hotel motel tax. But what I'm struggling with is, if that's true, why did you leave it in the referendum? And it's got nothing to do with the gist. It's just by leaving it in the referendum, it's confusing. Obviously, we're confused. Mm-hmm. And I'm trying to get at, and it's been suggested, well, maybe that's because it makes the referendum more popular, more enticing, more appealing. I mean, do you have an answer?
Well, I don't think that's the case. I don't think it makes it more enticing or more appealing. I think that you have a bundle of tax increases. The total when 1010 was passed in expected revenue was just short of $450 million. The hotel motel tax, the little cigar tax, which is also mentioned in the other protests, make up a very small part of that tax increase. And so what this is about, are we going to have increased taxes or are we not going to have increased taxes?
Well, I understand, but they're all taxes.
Right.
So you're making some kind of judgment here that people are only concerned about certain amounts of taxes and not all taxes.
I'm not making the judgment. What I'm relying on is the court's cases, the court's precedent that says only the major substantive details need to be included. If the outline of the gist, if the voters will not be misled, if the outline of the change that's proposed by the referendum is included in the gist, and when you look at the gist, there's nothing confusing about the situation at all. You talk about what's in the actual bill, but what we look at is the gist.
But the only chance that the voters get to see the entire text of this 1010, of RP 25 and 1010 is in the circulating referendum petition. The only time, unless someone wants to do their own research and get on the Secretary of State's website or the legislative website. So the only chance the voters have to actually ask to read the entire text is in the signing of this. And that's where I'm saying, and I think some of us are saying, you could have had severed out these sections very easily if you would have had the sections numbered, but in any event, it's misleading to voters who really care about understanding what this is all about. And when you present it to them for a signature, you don't know how they're going to look at this. They may actually want to see what it is they're going to vote on, because once we get to the ballot, it's only the ballot title.
Well, I think that's correct. And what I'd like to do is move to a different topic, because I think that this is all going to be the subject of the second protest. And what I'll do quickly is address the other arguments that were raised by the protestants here in this case. And that specific argument that's raised is, if you have a bill like 1010 that requires the toppling of another bill with an emergency clause, then the exception set out in Article 5, Section 2 applies, and you cannot do a referendum on that first bill, in this case 1010XX. And I think that's just simply not correct. The legislature...
But back to this other argument, we're still talking about millions of dollars that you don't think are significant enough to put in there.
Well, I think that what the court's cases require is the major details of the change. And I think the major details are included. And if you look in there and somebody wants to repeal the taxes, that whatever the taxes are, they're going to be repealed. Whatever's in 1010.
So you just see it as a generic thing?
I think it is. It's not a buffet with this bill. It's a pre-arranged menu. The issue is, will there be a tax increase or will there not be a tax increase? The issue is not, should we pass the hotel motel tax, or should we pass the cigarette tax, or should we pass the gasoline tax? That's a piecemeal view of it. That's not what this is about.
Wouldn't it be fairer to concede that the purpose of 1010XX was to fund a teacher's pay increase and for other educational purposes? And shall that be approved or not?
I don't think so.
Well, we don't want to let them know that, do we?
I don't understand.
Clearly not. No. I do. Because if you put in there that the purpose of either approving or disapproving the passage of 1010X has an effect on the intended funding of educational needs. And if you told the voters that, they might say, well, some taxes may be okay after all.
But I don't think that's what this is about. Like I've said, we do not believe that the repeal of 1010XX will affect the teacher pay raise.
Perhaps.
We do not.
1010XX was passed for the explicit purpose of helping Oklahoma education. You don't want to tell the voters that their rejection or veto or repeal or approval might have an impact on that legislative desire?
I think that 1010XX sends its money to multiple different places, the majority of which is not directly to education's public funding.
Why would they make the teacher pay raise contingent upon the enactment of that bill?
I can't answer that. That may be just politics and an attempt to kind of backdoor what cannot be done. In other words, to prevent a referendum on this tax increase. But that's the legislator's decision. All I know is that when looking at 1010XX, it does not contain an emergency clause. It is subject to the referendum power. The Oklahoma Constitution does not prohibit a referendum on laws that pertain to the support of public schools. There has never been any opinion of this court that has so held. That there's never been any referendum or initiative struck down because it pertains to the support of public schools. And so I think that this protest that addresses those issues should be rejected by the court.
Suppose I agree that 1023 and 1024 have been enacted and therefore effective. But let's suppose that 1010 is disapproved. Now you're saying hopefully revenues will exceed expectations, there'll be enough money. But if there's not, what happens? And the way I understand the balanced budget amendment and related provisions are that absent legislative action in the interim to account for the revenue failure, there's just a pro rata reduction that occurs to all funding. So in that event, if revenues did come in low and there was a revenue failure, I mean, this would at least in some manner affect the pay raises. It would be a pro rata reduction on all appropriations, but at least a little bit would be borne by the appropriation that funds the pay raises.
What matters is ultimately how much money is in the coffers, whether or not there will ultimately be a reduction. As we set out in the brief, we do not believe at this time, based on current revenue estimates, that there will be a reduction in any state services, and it will.
Next year, if you assume you are correct in that, what about next year?
Well, next year will involve a different economy, and it would with the increase of taxes for 1010XX if it went into effect. But ultimately,
so we're basing funding on 2 months of speculation.
No, I think that there shouldn't be speculation about what's going to happen, period. I think that this court's precedents and what all of this argument by the protestants is about is policy arguments. This court is not sitting here reviewing referendum petition number 25 from a policy standpoint to determine if it should be passed or if it should not be passed. That is up to the people. This court has said in the State Question 639 case, there was similar arguments. There might be a revenue failure. What will happen if there's a revenue failure? And this court addressed that. And I quote from the State Question 639 opinion, where the protestant explained that passage of the initiative would provoke a revenue crisis. However, such an argument provides no basis for judicial relief. So speculation about whether there will be enough revenue, whether there will not be enough revenue, I believe is not an appropriate basis for this court to make a decision.
Aren't you the one that put it in there?
Well, I addressed some of the issues that the protestants raised, but I believe it's not for this court to decide, and this court's cases say that there is no basis for judicial relief.
But didn't you just tell us, well, the coffers are full, it's going to be great?
All I can state is that the current economic report indicates that there will be a significant surplus, but once again, that issue...
And then you're telling us that doesn't matter, though.
I am telling you it doesn't matter.
Okay.
I don't believe that it makes any difference to this court's decision, and I think that the protestants' arguments in this matter should be rejected because the Constitution preserves to the people the power to submit a bill that contains a general revenue-raising clause, or that is a general revenue-raising bill, to a referendum.
But didn't the people delegate that power to the legislature? The Constitution, as I read it, says the people reserve to themselves the power to tax unless 75% of both houses of the legislature agree that a tax is necessary. So in my mind, they've delegated that power to the people, and I mean to the legislature. The legislature has lawfully exercised that power, and now we're faced with the people coming back and saying, no, we want to take that delegated power away from the legislature.
The Constitution was amended in 1991 to specifically allow, even after a legislative vote by a supermajority of both houses, to allow a referendum. That was one of the explicit purposes of State Question 640, which you can see in Article 5, Section 33, subsection D. It specifically prevents the legislature from adding emergency clauses to allow the people to vote on revenue-raising matters even after it's been approved by a supermajority.
Or enacted.
I'm sorry?
Approved or enacted, or effective or enacted.
Mm-hmm. Can you repeat your question?
You just said approved by the legislature. Was it enacted by the legislature, or was it approved by the legislature?
I think once it's signed by the governor, it's enacted. Thank you.
Mr. Stoney, rebuttal.
May it please the court, thank you. A few points in rebuttal. We honestly can't sit here today and pretend that House Bill 1010XX was not specifically passed with the purpose to fund Oklahoma public education and the teacher pay raise bill, the support pay raise bill, the public education support bill. This is why the Oklahoma legislature included contingencies in all of those other bills. They couldn't put an emergency clause in 1010XX because of Section 33D, but they did everything else. They put all these contingencies in, they put an emergency clause in the teacher pay raise bill, and that's what's happening. To suggest that based on revenue projections by the proponents in this case, that we are not in an education crisis, or that because of everything is going well, this court can't declare this law falls under the exception of Article 5, Section 2 as immediately necessary for the preservation of the public health and safety is simply not true.
So is it your position that 1023 and 1024 will not be effective if 1010 goes to the people and is disapproved?
My position is, why isn't the Attorney General standing up here and saying all those teacher pay raises are going to go into effect? Because the people that we represent are being told by their public school districts that those raises are not going into effect, that teachers are afraid to sign contracts because they're being told those raises are not going into effect, and the attorneys are telling the school districts that they're not going into effect. And the reason, I think, is because of the language that says, I mean, I feel like I'm having nightmares about the word enactment, but it also says, shall not be operative as law otherwise. What does that mean? I don't know. But again,
so I understand you might not want to take a position. I think that's what you're saying. You're not going to take a position.
No, I'm going to stand here and say they are in effect. Yes, absolutely. But
there doesn't seem to be a disagreement then. Mr. Bowers says the teachers get the money regardless.
And
do you believe they get the money regardless?
With all due respect, Mr. Bowers is a good friend of mine. I love Mr. Bowers. He's not the state of Oklahoma, and he's not 520 school districts across the state. What are they going to say? What are their attorneys going to advise them? And from our understanding, they're advising them, no, they're not, in effect.
Well, we might have something to say on
I agree.
That's why we're asking.
and if the court would like to take that position, that'd be great. But here's the problem. If the court or the state says that all of those raises are in effect, which is great, obviously. I mean, our organization fought tirelessly for that. But now you have a situation where the primary funding mechanism for those raises across Oklahoma is somehow going to be deemed not immediately necessary for the preservation and put on hold or a referendum. For the first time in 26 years, that law was passed by a supermajority, and now we're just going to say, okay, well, you still get to vote in November. We can't have that.
Here's my problem. Just last year, we invalidated the cigarette tax. That was a huge source of funding for the health department and otherwise, and that was in a dire economic time. We knew there was going to be a revenue shortfall when we did that the legislature would have to address. But we unanimously rejected. We didn't, I mean, because we don't look at maybe there is a shortfall, maybe there isn't. So why is this different? Why is it okay for us to do it there but not here?
Well, two reasons. First, you have all these surrounding bills that are contingent upon 1010XX. This court has the absolute authority and power to declare a law under the exception of Article 5, Section 2. Absolutely it does.
But what the appropriations bill last year was also accounted for. It appropriated out the revenues from the cigarette tax, so there was a shortfall once we invalidated the source of the money. I mean, it didn't have explicit contingency language, but it appropriated out the money such that we had an unbalanced budget after we invalidated the revenue.
Right. And the two differences, again, I don't know the details, but the two differences, in my opinion, would be you have specific contingencies here, which you didn't, assuming what you said, Your Honor, didn't in that case, as well as we have the support pertaining to public schools.
But is it still a legislative problem? I mean, if the teachers get the money, then the legislature is going to have to figure out how to pay them.
I think they did for the first time in 26 years. With a three-fourths majority.
But even if they vote to repeal that, and the teachers get the money, then they're still going to have to figure out a way to do it.
Yeah, that's called a constitutional crisis, because now you have deficit funding for public schools across Oklahoma.
But we've had 2 special sessions this year.
That's right. And with first time, and that's why we reject the Attorney General's position that this is going to open some floodgate. It's the first time in 26 years this has happened. And we can't ignore this court's precedent. I disagree with the assertion that this court has not spoken on this pertaining to the support of public schools. And back to Your Honor's point earlier about the 1991 case. House Bill 1017 had an emergency clause in it. If the court could have said, House Bill 1017 as a referendum petition is completely invalid because it has an emergency clause, end of story. It didn't say that. It didn't care. What it cared about was the fact that it was pertaining to the support of public schools. And this court has said that had 1017 been a referendum petition, it would have been invalid, no dispute about it, and quoted that language from Missouri. They were not concerned with the emergency clause in it. And that's why, because of 640, they couldn't put an emergency clause in 1010XX. It doesn't matter. It's pertaining to the support of public schools. And the question I have is, if there's ever been a situation in our state where the exception of Article 5, Section 2 needs to be invoked by this court, it's now. We'd ask the court to grant our protest and reject this referendum petition under the constitutional exception for the reasons that we've outlined and the precedent that's within the Oklahoma Supreme Court's ability to do so. Thank you.
Thank you, Mr. Summers. We'll be in recess in 117004. Go forward. All right. We'll now move to the second matter, which is case number 117020. And if council can move from the table, we'll give you a moment to do that. All right. We are now convened in 117020. The appearances in this matter for Oklahoma's Children, Our Future, Inc. et al., Mr. Kent Myers and also Melanie Rugani. Is that correct? And the appearances for the proponents of the referendum remain Mr. Bowers and Mr. France. The parties in this case have divided their time. Mr. Myers, 20 minutes in opening, 10 minutes in rebuttal, and Mr. Bowers will have 30 minutes in response. So, Mr. Myers, whenever you're ready.
May it please the court. On behalf of the protestants, I'd like to respectfully submit that this referendum is about as flawed as it could be. It is a genuine mess. The only defects that I plan to point out in my opening are those that deal with both the gist and the statement of whether or not there is an exact copy of the bill attached to the referendum petition. Let's start with the gist. It helps, I think, to refresh our memory about the purpose of the gist. when an initiative petition is drafted and filed with the Secretary of State, there also is filed a signature page that will be used as a form for all signature pages handed to voters when they elect to either sign or not sign the petition. At the top of that signature page must appear a statement of the gist, what the petition is about and what its impact is to be. There is no number of words that limit the statement of the gist. There is no content limitation on the statement of the gist. The gist has the practical effect of giving the voter, or the signer, I should say, whether or not they ever vote, giving the signer the opportunity to find out what it is that the signer is signing, what it is this signer is requesting be done. The gist fails in this case when focus is placed on 1010 itself. 1010 has 5 taxes that are referenced in the petition. Of those 5 taxes in the petition, or in 1010, I should say, 2 are omitted. The first that I want to discuss is the little cigar tax. I'm not sure what a little cigar is, but I understand it's different than a cigarette, and it is taxed at a different rate, and it has a separate market. For reasons that are not clear, the little cigar tax is totally omitted from the gist. Proponents suggest that this is a minor detail, that it is not significant. I suggest that if it's one of 5 taxes involved in 1010, it is significant for that purpose. There's $1 million in revenue that the Senate fiscal impact statement projected. It was significant enough for the Senate fiscal impact statement to refer to it, but nowhere in the gist will you find that this referendum petition is going to have anything to do with the little cigar tax. The omission of it on the signature page in the gist is, I submit, one fatal flaw that by itself is enough to invalidate this petition, but that's not all. I'd like to move on. We heard a good bit just a few minutes ago about the hotel-motel tax. Of course, the referendum petition has attached to it House Bill 1010. And in House Bill 1010 that is attached to the referendum petition, and a part of the referendum petition, is the hotel-motel tax. In other words, a signer wanting to know what they are signing, if they chose to look at what is right after the signature page, 1010, and they looked through it, they would see the provisions of the hotel-motel tax and could reasonably assume that what they're voting on involves the hotel-motel tax. But according to the proponents of the petition, that is not the case, that the hotel-motel tax has been repealed and is not part of this. So, looking at the petition itself, it has language in it that, according to the proponent, is not going to be affected by the vote on the referendum petition. That is misleading. That is misleading.
Can that be cured by the ballot title, or is your position it's uncurable?
No, I don't think it's curable for this reason. The ballot title for nobody that signed the petition, nobody that knew what was being promoted as being in the petition might go into the voting booth and read only the ballot title and then find out what the real story is on the hotel motel tax, that it's not included. But to this day, the ballot title has not been rewritten, as well it shouldn't have been, because the signatures have never been filed yet. But to the signer, it can't be cured by the ballot title unless the signer remembers what the signer saw when they looked at the petition, and then in the voting booth sees the ballot title and says, oh gosh, this must control over what I just read, and now I'm not confused anymore. I don't think that is an effective deterrent to misleading the signer/voter.
So even if the ballot title said, you know, this will in no way affect sections whatever relating to the hotel motel tax, your view is that the effect it had on the potential signers of the petition is what invalidates it.
That's correct.
Even if a voter would be properly informed.
Yes,
at
Your
the time
Honor.
to vote.
And
Do you think this could be amended so that they could add the entire bill and maybe put something in there that said it would have been repealed?
as to this particular referendum issue, no. But if you're asking, could a subsequent referendum petition be properly drafted and filed and circulated within the time necessary to get it ruled upon by this court and make whatever appropriate election deadline there may be? Yes. It can be done correctly. It wasn't done correctly here. And there's still time to correct it by any willing proponent.
But to do that, you only have 90 days. That 90 days is a fixed backstop, correct?
It is.
So even if if we rule on this and there's an amended petition that's sought, it still has to complete those signatures within that 90-day window.
Yes, Your Honor.
And if it fails to make those signatures within 90 days, it fails.
That's correct. Now, keep in mind.
Ask a quick follow-up, and this was something I was trying to ask of him. Let's assume that the gist did talk about the hotel motel tax.
Yes.
In accurate terms.
Yes.
Is the fact that they did a referendum as to the whole bill and the fact that the whole bill is attached a problem or not if the gist is accurate?
Yes, I believe it is. They had a way to avoid this because, as we know, in Title 31, OS Section 4, it is appropriate to seek a referendum on part of a bill. You don't have to go attack the whole bill, and it could have been avoided. But I would suggest in this case, even if the ballot title comes out correctly, the fact that the petition itself excluded the little cigar tax and, the gist excluded the little cigar tax and the hotel motel tax. Confusion cannot be assuredly assumed by correcting the ballot title. I don't think you can get there. Only way to get there is to start over or give up.
When I was in high school, I was asked to sell magazines. And my sales pitch was, you don't want to buy any magazines, do you? And it appears to me that Mr. Bowers has said that this is a generic tax and that all that's necessary is you don't want to raise any taxes, do you? How do you respond to that?
Well, it's hard to know exactly how to respond to that, but I would say that the import of this referendum petition with which we are dealing today is stop all of these taxes. I don't know that I could go beyond that.
But you think it's particularity, not generic?
Yes. Yes.
Thank you.
The gist is defective for another reason. It does not, as we've mentioned in our brief, a good part of 1010 is spent talking about where the revenue that's going to be raised by these taxes that are included in 10 is going to be directed. how it's going to be applied and whom it would be that would get the benefit of it. And that is not mentioned at all in the gist. The response to that was, that's simply a policy argument. I suggest it's not a policy only a policy argument as maybe thought of by the folks that are going to receive the benefit of it. They may view it a little bit more substantively than that. But that is not at all mentioned in the gist.
Do you believe that 1010's title is sufficient as enacted by the legislature?
Yes.
It makes no mention of the revenues going to education either.
Yes.
So, I mean, the purpose of a title is to inform the legislators of what they're voting on. And so if it's sufficient to do that, why does it need to be in the gist?
I'm not suggesting that that's the same standard, that the standard that might be necessary for the gist in an initiative petition where people exercise direct democracy rights may very well be, and I think is, different and more restrictive, or at least more exacting, I should say, than what might be required when the legislature takes action and the legislators themselves, professionals or semi-professionals as they may be, are equipped to deal with. It's not necessarily the same test.
Well, perhaps the legislature was better informed by the fact that they had a companion bill that was contingent upon the operation of the enactment of this bill.
Indeed. I'd like to talk a little bit more about the gist. Simply stated, it's backwards. It's misleading. An appropriate referendum petition, as required by Oklahoma law, puts for approval to the voter whether or not this act should be approved, should it be adopted. It isn't should it be repealed. That used to be the law in Oklahoma. That is no longer the law in Oklahoma and hasn't been since the early 60s. And yet the gist of this referendum petition would tell the voter, if you vote for this, you are repealing 1010. When in fact, the law requires that the petition say about 1010, should it be approved? And so if you vote yes to approve it, you're wanting 1010 to become law.
Well, doesn't that help you? Doesn't that help your position?
Oh, it does.
The voters are confused.
Well, in some respect, I mean, you heard the discussion. Well, I better not get, I can't refer back to the discussion I just heard. But in any event, it seems to me that it's confusing. It's backwards.
Suppose I agree with you that the ballot title is backwards, but that's not before us. We can fix that later. But the gist, it seems to me, the purpose of the ballot title is to inform the voter of what a yes and a no vote mean. The purpose of the gist is to inform me or give me some sort of knowledge of what I'm being asked to sign and whether I want to sign it.
Yes.
And if we phrase in the referendum context, which is different than an initiative,
yes,
if we phrase it in terms of, if you want these things, these tax increases, vote yes on this thing, I'll think I want to sign the petition, when in fact that's exactly against my interest.
Yes.
I don't want to sign the petition. So don't the gist and a ballot title have to be different in this context and the referendum context? No, not at all. The gist is simply to tell the signers what is in what is being requested, what is in the bill that will be submitted. Do you want, as a signer, to submit to the voters this bill to be approved? Yeah, and if I'm in favor of the taxes and in favor of the pay raises, the answer is no. I don't want this to go to the people because it was already enacted. I want the status quo.
Well,
so I don't want to sign the thing, but I would think that I want to sign the thing because I'm being told these are the raises, these are for the teacher pay raises. If you want these things, vote yes on this. And I would say, sign me up. And that would be exactly the opposite of what I want to do.
Yes, but I think you're right. And I think the gist as written, however, and as has or will be explained, is the intent of the proponents here is that the gist says, if you want to repeal this, vote yes. When in fact, Oklahoma law says, if you want to adopt or claim or validate 1010, vote yes. And those two things, of course, are exactly opposite. They just got it backwards, is all it is. And somebody said, how do you know if a yes vote is really a yes vote or a yes vote is to reject 1010? In fact, the law says a yes vote on a proper referendum would be to be for, be in favor of keeping and enacting, and, well, enacting's the wrong word, keeping and promulgating 1010 to become law. And the proponents here are saying, no, it's the other way around. A yes vote is to repeal 1010. That's confusing. And it doesn't have to be that way. It didn't have to be that way. The ballot title is limited to 200 words. The gist is not limited to 200 words, but this gist has 92 words when properly counted. It's extremely short and extremely cryptic and did not have to be. The suggestion that I'll make now is that there's another harm here from this confusion. If one is paying attention to recent initiative petitions, I realize they're different referendum, but initiative petitions or other direct democracy things that are coming up for a vote, there's a lot of public debate and there's a lot of public advertising. And sometimes that can be very, very significant in the outcome of the particular issue. And how are the protestants to this petition to advertise? Should they be advertising vote yes on this issue? Should the proponents of this petition be advertising vote yes on our referendum petition? I would hope that would be the way it would turn out if one were in favor of 1010, and of course my clients are. But the misleading effect of this gist is fatal, and it didn't have to be.
You were going to comment on the failure of the petition to attach an exact copy of the measure or portion thereof that is sought to be approved or subject to the approval or disapproval of the vote. And yet I thought I heard you say that a copy of 1010 is attached to the petition, and I have not seen the petition myself. So
it is attached. 1010 is attached, but it is not an exact copy of 1010. The failure to list section numbers in the attached petition.
Is that the only omission?
Yes.
There's no page numbers either.
No.
So there's no indication it was signed by the governor?
No.
Or approved by the chambers or filed with the Secretary of State?
Well, there are a number of defects that might be able to be overlooked, but the fact that hotel motel tax was repealed and the hotel motel tax repealer said we repeal sections 9 through 15 of 1010. Didn't use the words hotel motel tax 9 through 15. And yet you look at the attached petition to this referendum and you can't find 9 through 15 unless you just kind of guess and make some assumptions. My time is up, but I look forward to coming back in the final portion of this argument. And I'll come back to that if I may.
Mr. Bowers.
I want to know about the copy of this legislation. Where did you get a copy of legislation without any section numbers? And the way I read this, it looks like section numbers have actually been omitted.
Well, that is correct that the copy that was attached to the petition for referendum and filed with the Secretary of State does not have section numbers. I did not file it. I do not know exactly where it came from. My belief is that it came from the website before it was actually signed by the governor, and so it was printed off incorrectly. And I think that is the absolute definition of a technical error that substantial compliance addresses. And so I'll address that issue first, since that was the last issue addressed by Mr. Myers. And so the question in that issue with regard to the omission of the section numbers, to me, Your Honors, is does substantial compliance count? Because Article 5, where it says the text of the measure must be attached, it says that an exact copy of the text of the measure must be attached to the petition for referendum.
Can I ask you how you define, because I've been struggling with this, because we keep saying copy of the bill, but you're right, that's not what it says. It says text of the measure. What is the text of the measure? What's included in the text of the measure?
I would submit that the text of the measure is that the substantive provisions of the bill itself, the actual language that was enacted. And so I believe that the text of the measure is the words, the section numbers, the page numbers, whether the copy attached has the signature of the governor. Those are the formalities of enactment, but those do not include the text of the measure. And
basically everything that goes in the Green Book, the session law, I mean, would that be fair? Because it doesn't include the signature blocks. It doesn't include the sponsors and authors that are at the top of the bill. It just includes the title to the last bit of substantive text.
Correct. Yeah, what goes into the actual Oklahoma statutes book would be the text of the measure. And so these section numbers, the page numbers, those are not a part of the substantive text of the measure.
But the purpose of attaching a copy of the petition, the purpose has to be to inform a potential signer. They look at the gist, they should be able to ask for a copy. The petition itself should include a copy or an exact copy of the measure. And the exact copy language was added by the legislature after the court's ruling in 1959 or 60. A specific reaction to make the terms exact copy. Mm-hmm. Now here, a signer, when looking at the gist and doesn't understand it, I want to look at the petition. They go to look at the petition. The petition then has attached to it 50 pages. They don't know it's 50 pages because the page numbers aren't on there either. And they look at the sections and there are no sections. If you want to talk about the hotel motel tax, which is deleted from the gist, you have to go to the end, section 9, where it refers to an occupancy tax. Oklahoma Occupancy Tax Act. And then it refers to other earlier sections. How do they find that? How much time do they have to sign this? Do they have 90 days for one signer to go through it and make sure it's an exact copy so that they understand? I think that's the importance of the exact copy. We can argue about what the text is, whether or not it includes the signature of the governor. But you have to be able to find what's in it in order to understand it. At best, to me, this is sloppy. And at worst, it's intentionally misleading. It's deceptive.
I don't agree at all. I don't think it is whatsoever. You
don't think it's sloppy?
I don't know whether sloppy or not. It may be a technical error. And so the question is substantial compliance. I think at worst, this is a technical error.
The petition shall be in substantial compliance. The petition, the act, the requirement for an exact copy of the act is not substantial compliance. That's what the legislature did when they didn't like what the Supreme Court did in 1960. They changed the law.
I disagree with that. In 1960, the opinion that you're referencing, Justice Combs, addressed a situation where the proponents of a referendum included only the ballot of the title of the act that was at issue. They included only the title. So none of the text of the measure was included whatsoever. And so the response of the legislature to require an exact copy of the text of the measure was in response to the failure of the court to strike down that prior referendum, which only included the title of the act. And so I think that that's a totally different issue, and I think that this court has, for many, many years, found that the substantial compliance provision does apply to the use of the term a true and correct or true and exact copy of the petition. And so there's other requirements that a true and correct copy of the petition True and exact copy must be filed with the Secretary of State. And there are decisions of this court that are cited in the briefs finding that substantial compliance applies to that very language, which is identical to the language that's at issue here.
Well, the problem I'm having is, the section numbers do make it into the green books. And when you have internal cross-references in a law, it's like you need the section numbers. They're material. What I'm struggling with, and how do we define text of the measure? We know it's not copy of the bill because the 1961 amendment said you had to include the title in text of the measure. And then in 2015, we took out title. So we know it's not the title. So it's not necessarily what's an exact copy of the bill, or nor is it exactly what makes it into the green book. So this is what I'm trying to figure out. What is the text of the measure? Can we say there's a clear rule on what the text of the measure is, or just on a case-by-case basis we look and see whether we think enough was included?
Well, I don't know that it's necessary to get into that issue because, once again, I believe that when you look at it in this case, the omission of the section numbers is just a technical defect. And so to define...
But it's not an exact copy, is it?
It is clearly it's not an exact copy. Clearly it's not. But an exact copy of what? That's the question that Justice Wyrick poses, but I don't believe that's necessary for the court to address or resolve here. What is the text of the measure? I think that when you look at the substance of the actual language of the tax increase in 1010, that is identical on the engrossed version that was signed and actually will become law if this referendum is either rejected or does not move forward. The substantive language of that 1010 law is identical. It is an exact copy of that with the omission of the section numbers, and substantial compliance is appropriate in this case because it's not misleading. You have an opportunity.
The opinion from 07 rejecting the substantial compliance standard and adopting the strict standard?
Correct. There is a Court of Appeals opinion from 2007. I think that case, number one, is factually distinct because the referendum petition in that case that was filed did not include actual substantive text of the measure itself. It wasn't an omission like a section number or something like that, or a page number. That was actually missing the text of the measure itself. And so that case, I think, is factually different than what we have here. But then on the proposition that strict compliance is required, that is what the 2007 Court of Civil Appeals case holds. I think that's incorrect, and to the extent that I think this court should overrule that case to the extent it so holds.
To clarify, how do you substantially comply with the word exact? I mean, the Navy wouldn't let me do it.
Well, but this court has allowed it in the past, and that's the issue. You see that there are cases in the past.
I'm sure it was before I joined the court. Can you tell me how it is an exact copy which omits one of the taxes and then includes another one which has been repealed? How is that substantial compliance with the requirement of an exact copy of the measure?
Well, the copy of the exact text of the measure does include the hotel motel tax, and that's a part of the petition that was filed.
That's what I'm saying. It's been repealed. And that repeal can't be set aside in this referendum effort if it is successful, or even if it's not successful. That's a dead duck.
I agree with that.
Yet it's mentioned.
It is in the text of the measure because there is this requirement to include the entire measure when you submit this petition to the Secretary of State.
Cigar tax mentioned.
Well, I'd like to back up and address the first issue here, Justice, and that is because I think you're addressing the gist more so than the matter of the exact copy of the text of the measure.
I'm just reading section 2 of number 1 of Title 34.
And you asked me, how can it be substantial compliance when the word exact is used? And I would point the court to some of its prior decisions. For example, the case that was cited in some of the briefs,
I'd rather
in particular,
about the Court of Civil Appeals case. I think it's more on point here.
Well, this court's prior opinions are binding, of course, and the Court of Civil Appeals is only persuasive.
I stand chastised.
And the case I would refer the court to is in the matter of referendum petition number 1968-1 of the city of Norman. And in that case, it was held that a technical defect in the exact copy,
1968?
1970, after the 1960 amendments. And this addressed the true and exact copy of the petition, not the true and exact copy of the text of the measure, but still addressed that exact language. And so what happened in that case was the court said that a technical defect in the exact copy requirement is not fatal. Technical errors are to be disregarded.
What was the technical defect?
And so that was after the 1961 amendment. And
well, what was the defect held to be technical and not falling within the area of exact?
Well, let me see, Justice. I know I have that.
I can look it up. I'll withdraw the question, counsel.
Well, and so in any case, what the point that I would make is that substantial compliance is appropriate even though the word exact is included. And the inclusion of the substantive text of this bill, of this measure, is sufficient to show substantial compliance.
And you're saying this is the copy that the Secretary of State has on file as the final and gross version?
It's not.
No, the one that was submitted by the petitioners, or excuse me, by the proponents, did not have the section numbers.
Okay, I thought you said earlier you got that from the Secretary of State.
I think it, no, that's not what, if I said that, I did not intend to say that.
Where they got this?
I don't know where it works.
Because I can't find one that doesn't have section numbers.
No.
It just seems very unusual.
No.
But if you're talking about substantial compliance, that's a moving target. That depends on the facts of the case. I think exact probably depends on the facts of the case also. And a technical error could be punctuation. It could be something else. But when you have portions of this act that are included that have been repealed, you don't have any section numbers, so you can't cross-reference anything in here. So even if you wanted to discuss and say, well, I understand certain sections have been repealed because I got this other case, this other act that says 1012 and certain sections have been repealed, a voter, because you have to be a voter to sign this, whether or not you vote for it or don't vote for it later. So those voters have to be able to say, I am a smart person. I'm entitled to know what the real facts are here. But again, to me, and in the context of this, it doesn't mean substantial. It just doesn't. And maybe exact is overbroad too. But it just seems like the overall issue we look for in all of these cases are the voters misled. And that's my concern.
And I understand that's the court's role exactly, is to prevent fraud and corruption and deceit in this process. But I don't believe that that will be the effect of people signing the signature sheets of referendum petition 25. I think if you look at the gist of the proposition itself, it is very clear as to what those people are signing. It is very clear. It addresses the gas and diesel tax, it addresses the cigarette tax, and it addresses the gross production tax. If I am handed that signature sheet and asked to sign it, and I just look at the gist, I'm going to know exactly what's at issue. If I go and do due diligence and try to find out more details, I don't think that any of this will be a mystery. It might take some thought, but that doesn't mean that it's fraudulent or deceitful or corrupting. Yes, if a voter, a potential voter, wants to find out more details, there may be some things that could have been done better. But the court's opinions have said that's not the role of this court, is to find, could we have written it better, could we have done it better? It just simply doesn't amount to fraud or misleading the public or deception in this case. And so the point that I would make to the court as one of the final points is that when you have a referendum petition, I think that this protest can be resolved by the court's opinion in the State Question 639 case from 1991. In that case, the referendum petition itself, or that was an initiative petition that sought to repeal House Bill 1017. And in that case, this court said that the petition for initiative in that case fulfilled the requirement of the gist because it explains the effect of the proposal and it explains the total effect in that it states the purpose is the return of the laws regulating education and taxes to read as they did before 1017 became law. And so in this case, that is exactly the purpose of referendum petition number 25. It is to return the law to the status quo before House Bill 1010 was passed. And if you look at the gist...
No, it's to let the people vote on it.
Well, that's what this issue before the court is. We believe that the people should have an opportunity, but of course in obtaining those signatures, the purpose of referendum petition number 25 in the end is to repeal House Bill 1010.
That's your purpose.
I'm sorry?
Your purpose.
That is the purpose of Oklahoma Taxpayers Unite. That is correct. And so I think that the State Question 639 case is dispositive in following that case, this court should reject the protest that's been filed by Oklahoma Education Association and others. Thank you.
Mr. Myers? Even though you left time on his plate, you only have 10 minutes.
Thank you, Your Honor. Although it's always fatal to say, I hope I will leave time on my plate as well.
So do we.
Then I'll make sure that I do. Back to the exact copy thing. It's simple. Before we had the amendment to the statute that included the word exact copy, substantial compliance with the referendum was all that was required. But insofar as the method of successfully implementing the referendum petition to include a copy of what it is that is being referred to the people, that's where the legislature changed it and said you must have an exact copy. That was in response to a decision that had said substantial compliance was okay. Since that time, there are no Oklahoma cases that I'm aware of where substantial compliance has been authorized insofar as it applies to what you attach to your referendum petition.
What about the difference between a copy of the bill and the text?
Well, the text is, I think, everything that you must read to be able to understand the law that is being passed, that is being submitted. I would distinguish that from things that and I hesitate to give any examples because I can think of reasons why it might be necessary in any example I can think of. But it perhaps would not be necessary to have the title. It used to be title and text. I'm not sure title is necessary now. You have to attach an exact copy of the title of the bill. That used to be required. It is no longer required. But in any event, I think it's as settled as it's going to get that substantial compliance cannot be applied to the requirement to attach an exact copy of the bill, and that was not done here.
Well, as I recall that 61 case, we didn't have the requirement or at the time.
That's right. That's right.
Those protesting said adopt the Arkansas standard, and they cited the 3 Arkansas cases.
Yes.
Because Arkansas's Constitution had this exact copy. And the Arkansas Supreme Court at the time in those cases had said substantial compliance was good enough under Arkansas law, even though it said exact copy. And then we subsequently adopted the Arkansas standard exact copy, with Arkansas having already said substantial compliance is good enough.
Yes,
so, I mean, does that inform us at all whether substantial compliance is enough?
Well, it does, but I think what informs us perhaps more appropriately is the Court of Civil Appeals decision, which took all that into consideration and came to the conclusion that substantial compliance does not suffice for the copy, for the requirement of attaching an exact copy. I think that informs us as well as we can be, absent a decision from this court.
It seems to me there has to be some wiggle room. I mean, if I take the engrossed bill and just run it through the copy machine, but it comes out with one word smudged, the copier messes up, and I can't read what it says. Good enough?
Hard to know. Depends on what the word is.
Right, and I think that's my point, which is I am struggling with this. It seems to me it does have to be sort of on a case-by-case basis, look at what was omitted to see if it doesn't allow me to understand the measure. So exact doesn't exactly mean exact. It means enough of the text of the measure such that a person understands what they're voting on.
Yeah. My understanding, the Norman case from 1970 dealt with very small font that made it not very legible. It was the exact text, I think, with the section numbers, but you just couldn't read it very well. Where the factual situation here, even if we don't adopt COCA, rejecting substantial compliance, the text didn't include section numbers, so people couldn't refer back to what in the heck it was talking about.
Yes, Your Honor.
They wanted to learn more about it. To me, that's the difference, that our factual situation here is different than what the court looked at in 70.
I agree, and I think that the issue you have before you here on this bill that's been attached does not even meet a substantial compliance standard, even if the court should choose to adopt it.
It appears.
The absence of the section numbers in such a critical way cannot be fairly labeled substantial compliance.
Well, an exact copy in 2018 is a lot easier to come by than an exact copy probably was in 1970.
Indeed. In summary, and to try to give back a little time, the referendum is a second power reserved to the people. It's a sacred power. It's a power that should not be withheld from the people unless it justice requires it. On the other hand, the power of the referendum is not absolute. There are some restrictions on it. It must meet certain requirements. The gist has to be not misleading, and the exact copy has to be attached and the like. And the fact that it is such an important power even screams more loudly that restrictions on its misuse should be curtailed just as much as presumptions in favor of its use should be encouraged. Suggest to you here that because it's so misleading that one can't tell whether they ought to advertise to voters vote yes or vote no because they can't glean that from the petition is about as misleading as it can possibly get, and that has got to be beyond the pale of a permissible referendum. Thank you.
Thank you, Mr. Myers. That concludes the argument in both matters. Both matters will stand submitted at this time. We'll be in recess. The court is well aware of the time constraints on this issue. At this time, we've set this matter for oral argument within 40 days, so we're moving on pretty quickly. Thank both of you, all counsel, for your argument today. And at this time, without anything further, the court will be in recess.
All rise.